we have to more than ever before remain focused on the role NERSA in the growth of South African economy has to play. In this regard, the energy regulator must be able to effectively carry out its mandate, thereby contributing towards government's priorities aimed at the economic and social development of South Africa. Ladies and gentlemen, allow me to introduce the members of the panel who will be making presentations and answering questions. First, to my immediate right, I would like to recognize Advocate Nomalanga Stole, the CEO of NERSA, full-time regulator member and chairperson of the Regulator Executive Committee, a committee of the board. She will be elaborating on the legal mandate of the energy regulator in the two industries. To the immediate right of Mr. Tole, then we have Mr. Nhlanhla Gumede, full-time regulator member, primarily responsible for electricity regulation, chairperson of the electricity subcommittee, and will address us on how the energy regulator processed the Eskom allowable revenue application and on the regulator's decision. Finally, on my extreme right is Mr. Munzim Kiza, full-time regulator member, primarily responsible for petroleum pipelines regulation, chairperson of the Petroleum Pipeline Subcommittee, and will address us on how the energy regulator processed the Transnet petroleum pipeline system, tariff application, and regulator's decision. I thank you, Chairperson. Program Director, I will then hand over to Advocate Sito. Oh, is that?
Thank you, Chairperson, Mr. Mkwena. Good afternoon, ladies and gentlemen, and thank you for honoring NERSA's invitation to this media briefing. Mine is just to outline the basis, or rather the authority, upon which the energy regulator has in relation to the two applications that we have received from Eskom and as well as Transnet. The energy regulator is established in terms of Section 3 of the National Energy Regulator Act of 2000, with the primary role to carry out regulatory functions contained in the Electricity Act, the Petroleum Pipelines Act, and the Gas Act. The energy regulator, which is the board, has the final approval powers to applications made in line with the provision of its governing legislation for the regulated industries, as well as the regulatory tools or methodologies developed in terms of the said acts. With regard to the briefing session for today, it's important to indicate that the allowable revenue application for Eskom is based on the provision of Section 15 of the Electricity Regulation Act, and the application from Transnet, the Transnet tariff application is based on Section 28 of the Petroleum Pipelines Act. These provisions enable NERSA to regulate the revenue of Eskom and the approval of petroleum pipeline tariff. Further, the approval of the petroleum pipeline tariffs in terms of Section 28.6 of the Petroleum Pipelines Act prohibits a licensee to charge customers a tariff other than the one approved by the National Energy Regulator. It is important as well to indicate that the mandate that NERSA has to approve the tariffs for licensee cannot be arbitrarily exercised, as it is subject to compliance with Section 4 of the Promotion of Administrative Justice Act of 2000, and as well as Section 10.2, subsection 2 of the National Energy Regulator Act to ensure stakeholder participation. The applications received from the two licensees have gone through a rigorous analysis up to the stage of the recommendations to the energy regulator, and the process followed in considering these applications will be elaborated on by members primarily responsible for the two industries, that is Mr. Gumede and Mr. Mkhize. They will also share with you the decision made by the energy regulator at its meeting of today. Program Director, I think that's the brief outline of NERSA's authority or mandate in considering the two applications. I think.
Thank you, CEO, for the legal mandate on NERSA, and thanks, Chairperson, for the overview. As the saying goes, let's get into it. The decisions. We'll first have the regulator member responsible for electricity regulation, Mr. Gumede, to give us the presentation on the decision regarding Eskom's revenue application for the 22-23 financial year. Over to you, Mr. Gumede.
Program Director, Mr. Hlabela, Chairperson of NERSA, Mr. Mkwena, our colleagues, CEO of NERSA, Advocate Sitole, Mr. Mkize on my side, members of the media. I guess mine is a difficult one, and hopefully I will convey good news in respect of the work of the regulator. I'm not sure if I'm visible, if the presentation is visible. All right. You may need to do it there. I'm sharing it. It is not showing. You need to do what this guy did there. Yeah. All right, thank you. Hopefully you will see the presentation, which is the focus of today, which is the decision of the Energy Regulator on the Eskom's one-year MYPD5 revenue application and the emerging retail tariffs. For those who are on Teams, I'm not sure if it's visible, so if I can continue. Nkisa, can you see it? That's what was pressed earlier, and then we could press the same thing. Apologies for that. IT sometimes fails us. We did try it earlier and it worked when nobody was here, but that's in the nature of IT. What's that? Right. Look like I'm connected. This is not Will yours work in case? Just press this. Apologies for that. I always think that I've done, because we did do a pre-trial on this, and it worked on a pre-trial, including on Teams. But yes, hopefully it works now. Okay, thank you. If I may then proceed, members and the members of the media, and so this is basically what I thought we'll actually start this report back by providing a context for this MYPD5. That Eskom did submit an application for its MYPD5 3-year revenue application on the 2nd of June 2021, but using MYPD4 methodology. On the 30th of September last year, the Energy Regulator rejected Eskom's application. It rejected Eskom's application, but it had on the same day made actually considered three submissions, which is about the consultation on the revision of the pricing framework, number one. Number two, also the actual application. And then thirdly, to then request Eskom to submit a 1-year application based on one of the 4 options that were presented as interim arrangements. Eskom took the decision on review, as it is known, and on the 3rd of December, the court ordered the regulator to determine Eskom's 22-23 revenue application using the published 2016 MYPD methodology, and to make a decision on the revenue application by the 25th of February, which is tomorrow. Just to complete the picture, Part B of the application, which is to review and set aside the NERSA decision of the 30th of September, it is still outstanding. Now, I just thought I'll just indicate also the timelines that we are talking about. Following the court order on the 8th of December, NERSA published a consultation paper in line with the court order, and requesting stakeholders to comment on the application. The comments period closed on the 14th of January 2022, and we received 44 written comments from stakeholders. We then subsequently held public hearings, virtually, of course, for almost all of the 9 regions, except there was a physical public hearing on the 21st of January. And then, of course, as is procedure, the electricity subcommittee made recommendations to the energy regulator on the 14th of February, and the decision is going to be presented today. The energy regulator met this morning and made a decision a day ahead of the date set by the court order. Just to complete the picture, as you would know, that this is a revenue application. Based on this revenue application and taking into account all other approved revenues and any outstanding court order, that will then form the total revenues on the basis of which Eskom will then work out its retail tariffs based on the structure that has been previously approved. And the Eskom retail tariffs will then be approved by the Energy Regulator before the 15th of March 2022. Pictorially, to locate what I've just been talking about, it's important to remember that the current focus is really about revenue requirement, and it's the multi-year part of it. And it, by its very nature, excludes any other revenues that may have been applied for and approved before. Generally, once you've combined all of these revenues, you then work out what we'll then call an average price. But it must not be mistaken as that being Eskom tariffs, So I just wanted to indicate that coming out of the numbers that we're going to give today, those are indicative numbers that you see on the screen. So I don't confuse I don't confuse you here. But once we have those numbers, the revenue numbers, then Eskom takes those revenues, combine them with all other previously approved revenues, and it then takes that through an ERSA process, the Eskom retail tariff process, and then it comes back to the Energy Regulator to approve those. And based on those tariffs, the municipalities take whatever process that they would have negotiated with Eskom. Some of them buy, different municipalities buy at different prices. Some buy at Megaflex, some buy at Home Flex, and others. That we then take those prices combined with the guideline, that the municipal guideline that would have been developed, and then by June, hopefully. At the latest, is that then NERSA will then be able to then approve municipal tariffs. I just want to clarify this issue that NERSA only sets Eskom's revenue. It approves all others things, but it does not set those tariffs. It approves them, but it approves Eskom's revenue in terms of the current regulatory framework. Now, if we can go to the numbers. Eskom applied this year for in terms of the MYPD allowable revenue for 2022-23, excluding RCAs. What you will see in the application, there are RCAs that are highlighted at the bottom of the presentation of the slide. There's a number of 14.412 billion in terms of RCAs. Those were not up for negotiations because those the Energy Regulator had previously made a determination thereon. So they were not up for a discussion. It was those are previous NERSA decisions. So the only applications that were really made were in the areas that are actually highlighted before, which totaled an amount of 279 billion for the year 2022-23. I've just highlighted for your benefit, the bigger numbers, which were drivers for this MYPD 5 year one application, which clearly the regulated asset base RAB being the biggest driver, in the sense that it contributes towards firstly a return in terms of the cost, because a return in terms of the cost is actually a regulated cost, and also contributes towards depreciation. So those are the numbers that were applied for by Eskom. But in fact, Eskom had applied for the 2022-23 financial year, had applied for a negative return. So that's the number there. That's that number of 25 billion. But as you can see, the biggest number is basically primary energy, well, followed by IPPs at 70 billion, and then depreciation at 68 billion, and then operating cost at 66 billion. So those were the key drivers for this application. The Energy Regulator, in making the decision, made a number of adjustments. And again, just to focus on the 5 areas, the key areas where the adjustments were made. Again, this was done in accordance with the MYPD4 methodology, which basically looks at Eskom's assets on a replacement cost basis, using the modern equivalent basis. So basically, all assets are revalued in accordance with that methodology. So Eskom had proposed a figure figure close to 1.3 trillion rand, and in terms of the depreciated RAB. But what the colleagues have done is, in the analysis, they've adjusted that down to a number close to 700 I guess, billion. And Eskom has indicated it applied for the negative return. We then, in considering, the Energy Regulator approved a positive number, not to the extent to which, in terms of the weighted average cost of capital, Eskom's weighted average cost of capital, which is in the tune of 7%, but adjusted it down, so from a negative, but to just over 1%, which yielded then a return, a positive return of just over 7 billion. And then also then Eskom considering the issues related to IPPs, because IPPs, if you recall in the first slide, that the IPP costs were around 70 billion, but because of mainly timing of a number of these IPP projects that were supposed to come on stream, and which were definitely not going to come on stream in the 22-23 period, that adjusted that down. And the Energy Regulator further adjusted that down to some number close to 43 billion. But this is informed by the actual project dates in terms of which projects will definitely come on stream in the year in question. So to compensate for that, the primary energy was adjusted up because all of the shortfall that was going to be emanating from the IPPs not coming on stream had to be met via coal-fired plants. So the primary energy then was adjusted up, both in terms of coal costs as well as diesel costs in terms of the use of CGT. That's number one. And then the other one that I'd like to talk to in detail a little bit is the figure under arrear debt, a figure of 5.6 billion rands. As you know, Eskom had indicated that, in fact, and I think this is actually very, very well known in terms of the legal fights between Eskom and municipalities that are not servicing the bulk account, that in fact the number was always much higher than that number of 5.6 billion. However, that was adjusted down after discussions with a number of departments, including the shareholder department, to indicate that it's not that cost is not a real cost for Eskom. However, it's perhaps a cost that is better handled somewhere else, including what I think has been seen on TV in recent times with municipalities themselves shutting down even government departments that are not paying their bills, that we need to make sure that everybody pays their bills and not penalize people that are paying. And hence that has been removed. But it is a real cost that Eskom faces, but that needs to be handled slightly differently. So those are the areas, the key areas that were adjusted. Now, what that then resulted in, Eskom, in fact, if you looking at just the revenue for 22-23, had applied for a revenue. I know that we tend to express the actual application in terms of a percentage tariff increase, but remember, this is just revenue. It's meant to be revenue. They applied for 279 billion, which needs to be compared to 233 billion, which was for FY 21-22. But in terms of the impact on the tariff, what they had applied for was 14.58% for the new revenue. I'd like to stress this, that because of all of the activities in which also, and we have to also thank Eskom themselves in terms of engagement on this, we managed to actually contain that increase to below inflation. It is, and I don't know how to stress this, but it is in terms of the new application, the actual increase that has been approved by the Energy Regulator is 3.49%, which is way below inflation. This was done to balance the interest of Eskom with those of the economy and other stakeholders. But of course, taking into account other things like I've indicated, that the 5.6 billion, which is owed specifically by government departments, needs to be paid. But it needs to be paid by those departments that are owing Eskom. So that is in terms of the 22-23 revenue application. However, as you know, that unfortunately our system works with, you have to then add all previously approved RCAs. When those are added, then the increase becomes 9.61%. That is the increase that has been approved by the Energy Regulator. Eskom, as it's been publicly announced, had actually applied for that revenue application that they made, which expressed in terms of average tariff increase, is been presented as 20.5% increase, and the decision of the regulator has been 9.61% increase, which is less than 10%. It is a single digit. This again, it was done. It was a balancing act, which was done to balance the interest, taking into account the state of our economic recovery, to balance the interest of the economy and that of the consumers, as well balancing that with the interest of the utility. In summary, and in finding, essentially, just want to reiterate that the Energy Regulator made a decision today that in respect of the current decision, in terms of revenue application, in terms of the application for the revenue for 22-23, the increase has been 3.49%. But when legacy decisions are added, the tariff increased by the impact on the tariff will be around 9.61%. By the way, that to be for Eskom customers and of course for municipal customers, because that increase will need to be prorated from, because the municipal customers, the tariff increase will come into effect in July, whilst for Eskom customers will come into effect on the 1st of April. So for the municipal tariffs might be slightly higher than that, but in the main, the tariff increase that has been approved, including legacy decisions, is 9.6%. So the other point that I just wanted, which has been raised, which also been raised by the Energy Regulator itself, is the issue of the outstanding 59 billion rands equity injection or the government grant. That is not part of this decision. It will be, because it is subject to a particular court order which is actually being appealed. We've been having lots of conversations on when this process can start in terms of, because the actual NESA decision was reviewed and set aside in July of 2020. But in terms of how that decision will then be revisited, that process will actually start immediately after conclusion of this process, and will then work out a mechanism that again supports both Eskom as well as the economy in terms of how the outstanding 59 billion out of the 69 billion will then be handled. And just as the last point, of course, has been said a number of times, all these decisions are also subject to investigations on governance failures at Eskom that are yet to be concluded. But those that have been concluded, any of the actual results coming therefrom have been effected. That brings it to the end of my presentation. I thank you.
Thanks, Mr. Gumede, for the presentation. I see a hand from Chris. Chris, is a question or are we not audible?
It's a question.
If I may, Chris, We haven't arrived at that item for questions and answers. We are going to take another presentation on Transnet's decision. If you can please pardon us. Thank you. Mr. Mkhize, it's your turn for the presentation. Over to you. Thank you. Thank you very much, Chairperson. Mr. Mkwena, then CEO, Advocate Stole, Mr. Gumede, my colleagues with me here. Thanks, Program Director, Mr. Klebela. And thanks to all the members of the public, those that are attending with us here physically and those that are connecting virtually. My name is Muzi Mkhize, as already been said. I will present the decision of the Transnet pipeline system tariff application for the 2022-2023 financial year. I hope my screen can be seen.
You can see it, just continue.
Okay, thank you. And it's nice to present at the back of a budget speech that for the first time in many years has not had an increase on the general fuel levy as well as the road accident fund levy, noting the economic recovery that the country seeks to be on. And the fact that Transnet launched this application on the 30th of September, having asked for a postponement, a delay, an extension of about 60 days because of the challenges that they had, which I think are known to most of us. But I also would like to echo my sentiments around our cooperation with Transnet to thank them, as well as the team working in the Petroleum Pipelines Regulation Division that they've always collaborated and worked well together, particularly when it comes to pre-application meetings, which help in terms of having a licensee to understand what is required of them. In terms of my presentation outline, I'll just then talk to the overview of the application, then talk to the update on the multi-product pipeline project, then look at previous NESA decision, and that will be all in essence. Transnet applied for a revenue, allowable revenue for about 9.8 billion. That would then mean a 77.54% increase in the allowable revenue from the 2021-2022 determination, which was 5.5 billion. That is mainly attributable to the clawback in favor of Transnet of about 2.5 billion. This is mainly due to lower volumes that were realized in the 2020-2021 financial year, which amounts to about 1.6 billion. That contribution, as we know that we had a Black Swan event in the COVID-19 pandemic affecting the globe. And then there was also the high, actual OPEX that occurred in the 2020-2021 financial year. That was mainly due to product theft on the Transnet pipeline system.
I don't think that there is any time in the history of this country where the issue of safety and security is so closely related to economic well-being of the country like now. And this also talks to the issues that talk to product theft. We know about the July events. We know about also, even in the electricity space, the issue of copper theft and all that. So safety and security cluster has got a big role to play in terms of assisting. And I think that us also as communities need to also to be aware that in one way or another, this will comes to bite all of us. As you can see, there a value of about 375 million that then is lost to the economy as a result of such activities. There was also a deferred allowable revenue from the decision that the regulator took for the 2019-20 financial year, that determination, which is about 304 million. There was also a higher weighted average cost of capital, which then resulted in the return on investment of about 965 million. Transnet also forecasted volumes of about 14.7 billion litres, which is 7.26 lower than the 2021-2022 financial year. The decrease in volume, coupled with this 77.54 increase in the revenue, would have resulted in pipeline tariffs of an increase of about 83.15%, which would then mean that the Durban to R Road tariff would increase from the 52 will increase from 52.2 cents per litre to 95.62 cents per litre. That would have marked an increase of about 2.38% in the eventual pump price. Then in terms of the energy regulator now looking at this decision and taking this decision, it approved the allowable revenue of 7.5 billion, but in terms of smoothing, because our regulations do allow the regulator to then take into consideration other relevant matters that will help in terms of alleviating or cushioning, in other words, the consumers, which then translated into a situation where 80% of this allowable revenue was included in this year, with the remainder, which is about 1.5 billion, being deferred over a period not exceeding 5 years. The energy regulator then, in terms of the tariffs that it has set in this regard, there's a 9.1% increase from the 5.5 billion to the 6 billion, which is as compared in the 2021-2022 tariff period. This then translates to about 8.02% tariff increase for the Durban to R Road route, which then means the petrol price, the fuel price at the end of the day is going to be 4.18 cents per litre higher, moving to about 56.39 cents per litre. In terms of the summary of the decision, is that they had applied for 9.8, they are getting 6 billion instead. The increase was going to be 77.54%. They are getting 9.1810%. The tariff increases are going to be, instead of 83.15, it's going to be 8.02%, resulting then in the increase in the tariff not being the 43.41 applied for, but 4.18 cents per litre. That is the decision that was provided. And here, in terms of the decision, just to indicate that what they had applied for vis-a-vis what the regulator determined in terms of the regulated asset base, which then came out lower because the regulator decided that those assets that have not been operationalized as part of the multi-product pipeline will not be included. That is mainly because even in previous periods, Transnet made estimates, but they failed to meet those dates. So it was then decided that the best is to let those assets be operationalized, and then the regulator can claw back on that instead of including it before they are actually operationalized. Hence, then it resulted in also the reduction in terms of the return on assets. And then that is why then you have a total allowable revenue being 23.18% lower than what they had applied for. The operating costs, I've already spoken to the issues of product theft, but there were also other elements that are not included as such into the OPEX. But those are also expanded upon in the decision and reason for decision document that is going to be published by the regulator in due course. The issue also of the prudency findings that also had an impact in terms of the clawback because previously we're standing at an imprudent amount of about 3 billion, which then when the regulator further investigated, it came to a figure of about 4.368 billion, which is higher, and that has been discounted in this process. I think the next slides mainly talk to the issues that I've already alluded to in terms of the operational non-operational assets that have been excluded, and certain operating assets not allowed, as well as the implementation of the NERSA prudency findings, which is something that has already been communicated to Transnet, particularly Transnet Pipelines Division. And it was also noted that in terms of the clawback, we can't just really say that the consumer must bear all the loss of the volumes, because there was COVID-19, which is a black swan event, and therefore we had to only take 50% of that in terms of recognizing the volumes that were lost. Then the other issue was just the different corporate tax rates, which were also confirmed yesterday in the budget speech that is going to be the 27% instead of the current 28%. Then there was also the issue of smoothing the tariff, as I alluded to, giving the 80% now and then the 20% over a period not exceeding 5 years. That is allowed in terms of the regulation 41D of the regulations made under the Petroleum Pipelines Act. With regard to the project itself, there are two outstanding assets that need to be completed. One is the replacement tanks for the subref in Durban that Transnet used that space, and then the arrangement was that they were going to build the tanks for them and hand over to them. The indications are that they are going to be completed by 31st of December 2022. And then the TM1 tanks, which is the terminal in Durban, it's going to be finalized by 30 June 2023. That's the figure that the timelines that have been provided. But we have not included them as such as in the RAP, the regulatory asset base. I think the rest of the issues, members, in the interest of time, you can read for yourself in terms of the trunk line. But I must also emphasize that should there be, if volume increases, that will be enabled by being able to by installing pump stations in the future. So, but still, I think the line is still sufficient to supply the inland market. This is just a summary of the previous decisions. As we have noticed that we have been able to keep it in single-digit figures in terms of the increases thus far, noting that there is that deferment of 20%, as well as also the new assets that are likely to be brought on board in terms of the regulatory asset base, which are then going to have to be to affect the future determinations. This then brings me to the end of the presentation, and thanks to everyone for your attention. Thank you, Chair and Program Director.
Thanks, Mr. Mkize, for the presentation. I think before we get to the questions and answers, the chairperson will just give us a summary of the two decisions. Over to you, Mr. Mgwena.
Thank you very much, Program Director. Let me thank my colleagues for their presentations. What I'm supposed to do here is just to reiterate the highlights of the decisions of the Energy Regulator this morning. In relation to the Eskom multi-year price determination revenue application, subject to further scrutiny of some of the following conditions which the Energy Regulator has set, all costs allowed in the determination allowable revenue will be subject to prudence review, efficiency test, and percentage threshold. Secondly, there will be performance of independent valuation of Eskom regulatory asset base, conduct further performance audits on Eskom's generation fleet, and await the outcome of the investigations relating to governance failures within Eskom. Now, the decision, therefore, is that based on the total application for revenue of 293 billion, which then amounts to 20.5% in terms of tariff, the Energy Regulator has allowed 250 billion, translating to 9.61% in terms of tariff. Then that particular tariff includes the RCAs. If before including the RCAs, as Mr. Gumete has pointed out, the then tariff becomes 3.49 against 3.49 against the 14.58. Now, the Energy Regulator will be eagerly awaiting the Eskom retail tariff structural adjustment to consider it before the date set indicated by Mr. Gumete, 15th of March. And finally, the 23 billion, which is the 59 billion as indicated, is a matter that will be dealt with after legal processes have been finalized. That's the essence of the decision of the multi-year price determination. In relation to the petroleum pipelines, of course, subject to the MPP assets, which are still to be subjected to further prudency assessment and verification. Secondly, assets admitted into the regulatory asset base will be verified based on the prudence review, and all costs that are included in the determination should be subject to further verifications, audit, and investigations, and prudency assessment. And further, should Transnet not be able to meet its financial obligations, then the Energy Regulator may reconsider the smoothing decision in terms of the suspensive decisions made. As a result, therefore, the Energy Regulator, given the allowable revenue applied for of 9.770.72 million, the Energy Regulator has approved an amount of 6,000.08 million, which is 6 billion. And that billion is about 80% of the allowable amount, which then will be paid 80% for the year, and the remaining amount will be smoothed over the remaining 5 years. I think that is the essence of the decisions of the Energy Regulator today, ladies and gentlemen. I thank you for your attention.
Thank you, Chairperson Dr. Mokoena, for that summary. Colleagues, we have come to the item I think that most of you have been waiting for, the question item. Before we go to the questions, I would just like to indicate to colleagues that the media statements and the remarks by the chairperson as well as the presentations will be distributed, so they will be emailed to all of you. In terms of the questions, I'll request that we first, we take a first set of 4 questions. Let's make it 5, a set of 5 questions, and then we'll go to the second round. We'll start with colleagues that are joining via Teams. Colleagues that are with us here, they've got a home ground advantage. So we will start, with colleagues joining, via Teams. And I just want to request that before you ask, your question, please just introduce yourself and the media house you are representing. And also switch on your camera. We want to see, your face. Yes, we can take questions. I see Chris. Yeah, your hand has been up for quite some time. Yes, it will be Chris, Carol. What's this one? We are South African. Yeah, we are South Africans. And then Terence. And then from here, it will be Antoinette. In that order, Chris, Carol, we are South Africans, Terence, and then Antoinette. Chris?
Thank you, Chairperson, and thank you, Charles. 2 questions, if I may. I understand that the Electricity Subcommittee, about a week or so, recommended a much higher revenue and therefore price increase for Eskom. And this was today revised downwards by the NERSA board. Please, can you tell us what the revenue that was recommended by the Electricity Subcommittee, so that we can compare that with the revenue that was allowed by the board today. My second question, please, can you please indicate the timing and the quantum and the phasing of the expected further price increases that will come from the consideration of the 59 billion rand of equity injection that was unlawfully disallowed by NERSA previously? And please, can you indicate whether NERSA has in fact conceded this amount or not? Because in earlier NERSA documents and spreadsheets that were publicly made available, it implied that NERSA was going to give this 59 billion rand back to Eskom even before the outcome of the appeal had been heard. So it gives the impression that NERSA has conceded on this point. Can you please clarify that for us? Thank you.
Thanks, Chris. Carol?
Good afternoon, everyone. Thank you very much for the opportunity. You were saying that this decision was made in the interests of the economy and of stakeholders, balancing, I think you said balancing the interests of Eskom with the interests of the economy and stakeholders. Now, my understanding is that your hands are actually quite tied to the extent, in the extent to which you can actually balance the needs of the economy, in that you have to follow a particular methodology. Now, if did you follow this methodology to the absolute letter, or did you change, or did you take into account the economy and then therefore change your decision? And if so, I mean, what kind of guards against Eskom later taking this to court, as they have done many other applications, and getting or doing an RCA and getting the additional tariff added on later down the line? Thanks.
Thanks, Carol. We'll go to We Are South Africans. You are not audible. I'm sure you're on mute. We can't hear you.
You need to speak. The problem is to just remove him. Speak directly. Ask him to check his side.
Is your mic on?
He's muted now.
Yeah, but yeah, it's muted here.
You need to. He's using the headset.
Oh, okay.
Went off.
Okay. Okay. Can you remove your headsets?
Unplug them, not even
and unplug them.
Unplug them.
We can't hear you. Remove your headsets.
Look out. He went out and come back in.
Okay. Whilst he's still, sorting his audio challenges, can we go to what's the Terence? Yes. Over to you, Terence.
Thanks, Charles. I wonder if you could offer some insight into how the regulatory asset base was recalculated, because the NERSA figure is materially different from this figure, and it seems to be lower than the figure that was in the previous financial year, approved for 2021-22. So if you could give some insight into that recalculation, because it has a material effect. Which department has made the offer to deal with the arrear debt outside of the regulatory process, and how exactly will this cost be recovered now? And thirdly, have all the RCA amounts that have been approved, the legacy amounts, are they all liquidated in the upcoming financial year? Thank you.
Okay, thanks, Terence. We'll go to Antoinette.
Antoinette Slowert from Rapport. Mr. Gumede, you said the arrear debt is not a real cost for Eskom. What did you mean when you said that? And what do you expect Eskom to do? Should they cut off municipalities and leave paying customers in the dark, or what do you expect to happen there? And then I would just like to know whether you consider the 3.49% increase cost reflective. And then also, you said during the ER meeting that you met, between the ELS meeting and the ER meeting, you met with, among others, Minister Montage. What was the outcome of that meeting, and what impact did that have on your decision, if any?
Thanks, Antoinette. I see we are South Africans is back. Let's try again. Maybe this time will be audible.
it's not only you guys that have technical problems.
Yeah, we can hear you now, loud and clear. Go
Sorry.
ahead.
Okay, Gilbert Martin from We Are South Africans. We're the largest civil society movement in South Africa. I have two questions for NERSA. As the body responsible for energy regulation, and it's a request from our members and the people, when will we as people see NERSA respond to the load reduction and load shedding, and obviously this non-security on the assets of Transnet, Eskom and municipalities that are failing us, and are under agreement with NERSA to supply certain standards as such to the people of South Africa, which they are not. We are paying, and the increases are coming and flowing, but no one is taking responsibility for the failure of our systems. That should be part of the consideration of the granting of these applications and these increases, and no one is taking anybody to task regarding it. That is the only question I have.
Thank you. Thank you. I think the panel will decide in terms of who's going to be taking which question.
We'll just take the Montage.
Thanks, Program Director. I guess I'll tackle the majority of them, and I'll request my other colleagues to assist where necessary. And if there is further detail, I'll be able to direct people to the RFD. I might not remember those details, some details. But I'll let you start with the question from Chris. Chris, can we clarify something? In respect of tariffs, there is only one body that can make a decision, the Energy Regulator. All that the committees can do is recommend. The reason why we never share the numbers that are actually recommended by committees is because those numbers are subject to change. They are not final numbers. There are only one set of numbers that are Energy Regulator numbers. The Energy Regulator numbers like today, the only numbers that we can make reference to are the numbers that were made, the decisions of the energy regulator today. Even in conversations with stakeholders that which are mainly courtesy conversations with key stakeholders, could well include people that need to take into account some of the impact of decisions like the governor of the Reserve Bank and so forth, is that we clearly indicate that the numbers that we are putting in there are indicative numbers. In fact, they are always presented by the chairperson of the electricity subcommittee. They are not presented as the numbers of the energy regulator. So, Chris, we will not be able to share preliminary numbers, and those numbers unfortunately change every time. I mean, they change up until the final day when the energy regulator makes a decision. So that's the first one. The quantum of the implementation of the 59. So there's a bit of feedback. The quantum of the on the timing for the implementation of the 59 billion. But I'm not sure if I should continue. Anyway, let me just try. Okay. We try again. Okay. then it then needs to be taken back to court, and then court will then actually make that as an order of the court. So I'm hoping, Chris, I have responded to your question. So I will not be in a position to give you the actual quantum at this stage, nor the timing, because that is subject to a conversation between Eskom and NERSA. Coming to the questions asked by Carol, did we follow the MYPD4 methodology? Yes, we did. And the MYPD4 methodology does allow discretion to the energy regulator. The discretion may be limited, but the discretion comes from, for instance, in terms of asset valuations. There's a question asked by Terence around how RAB was calculated. As you would know, if you put three accountants, and I guess the same with lawyers as well, if you put three accountants in one room and ask them what the value of my laptop is, they'll probably give you three different values. It is not unique to us. However, the MYPD4 methodology, it stipulates that we must use replacement value. But when we use replacement value, what does that mean? And it stipulates, and I think in this particular case, it's been specific, and we've used modern equivalent. But when we use modern equivalent in terms of an asset, what does that mean? So if you've got an asset, say you've got a plant, Tutuga, that may be operated, and please don't quote me if I actually said something wrong here, but in terms of the wrong numbers, but it may be operating, say, at 20% EAF. If you actually have to look at value that asset in terms of its modern equivalent, you would then have to say that asset, yes, its value, if you were to build it today, would be a particular value. But if you build it today, it will then be operating at 85% EAF. That is energy availability factor. And it would have a particular maintenance profile because it's actually a new asset. But those values clearly, depending on who's evaluating those values, you may get different numbers. But the methodology, the MYPD4 methodology allows that. Where NERSA has lost it before, which is why we have lost in most cases, has largely been because of procedural fairness. That the methodology is a guide, but in applying that guide, you need to apply it in a manner that, as you apply that guide, you need to apply it in a manner that balances, that allows the affected party an opportunity to also allows the affected party an opportunity to comment and to agree to whether it actually at least understands and agrees with your position, which previously we had not done. We had subsequently changed our procedures that even between the recommendation of the electricity subcommittee and the decision of the energy regulator, we then consult with Eskom or whichever applicant in respect of whatever application that has been made. So procedural fairness has largely been the challenge that NERSA has been facing. But the methodology itself is a guide. It is not prescribed. It is not one of those which is prescribed by way of regulation. It is a guide. And it is a guide that's supposed to give you rational outcomes. So if the outcome that's going to emerge is not going to be a rational outcome, clearly the regulator needs to use that methodology guidedly. I'm hoping I have answered that question. And I'm also hoping I've answered the question raised by Terence around the RAB, how it is calculated. It is a modern equivalent value. And I've gone to depth in terms of trying to explain that. Which department has offered to deal with area debt? It's actually not one department. So as part of the decision, or in terms of before the decision that is made by the energy regulator, as indicated, we do consult a number of government departments, mainly for information purposes. But during the public hearings, for instance, there was an explicit indication and request, even by stakeholders, that says, if there are policy decisions that and the policy decisions result in costs for Eskom, that the implication of those policy decisions may need to be communicated with those departments that are bringing up those costs, and that perhaps they can then begin to contribute towards the resolution of those costs, and that in some cases, even where possible, to actually have those costs be deferred. In terms of arrear debt, of course, we've got a number of government departments who are owing Eskom. We've got municipalities that are owing Eskom. So we have had conversations with COCTA. We did have conversation with DPE. We have had conversation with DMRE, and the intention was to also have conversations with the governor as well as National Treasury. But in the main, is that it's going to be our collective, is all of government's collective efforts that says you cannot have an SOE who is owed money. By the way, Antonio, can I correct if you had me incorrect? I did not say that arrear debt is not a real cost. I said arrear debt is a real cost for Eskom. It's just that the manner in which it is collected, should it be collected from those paying customers, or should that be a concerted effort by all of us, government and individuals, to make sure that we pay that and not penalize the paying customers by burdening them with an additional 5.6 billion of revenue just because of the non-paying customers. So there is going to have to be a concerted effort by government departments, all of government, to ensure that at least government departments do pay what is owed to Eskom. And of course, there's have to be a concerted effort to get the municipalities to do the same. But the cost that is experienced by Eskom is a real cost. If I said something different, I add and I apologize. That's not what I meant to say. So in terms of which department offered to deal with that, in fact, we're looking at the whole of government, and we need to all have a concerted effort to actually do that. But we should not make consumers that are paying to be the ones that carry the burden of non-paying customers. All RCAs have been liquidated. As indicated, all of the previously approved RCAs and previously where there was an implementation plan on them have all been liquidated. Some of them date back to MYPD3, as I think that those details can be provided. But the only RCA, there are two RCAs that are still. There's an RCA 2019-20, which was decided upon by the Energy Regulator last year. There has not been a decision in terms of how that will be liquidated. That decision will be made soon, but it will actually, unfortunately, miss this particular implementation period. But all RCAs that have been made, other than the ones where there is no decision in terms of liquidation, have all been liquidated. The 3.4%, the 3.49% cost reflective tariff, Antoinette. This is a very subjective question, because if you have to ask yourself, when you say something is cost reflective, firstly, which cost are we talking about? We need to be quite clear. So in respect of saying, is the 3.5% reflective of the costs, Eskom's cost to provide the service? Eskom has applied for a certain number. And yes, unfortunately, especially when we are talking costs that have got opinions on them. For instance, depreciation as a cost, and of course, the regulated asset base. That unfortunately, and any costs that are based on the regulated asset base, which by its very nature is based on an accountant's opinion, is that you then need to say for the cost, but there are real costs Eskom faces, coal costs, diesel costs, and to the extent of those costs, we like to believe that the approved amount has gone to a greater extent to actually approving those costs. Yes, a return is a regulated cost. and it's covered in terms of Section 15 of the Act, 15.1 of ERA, that says for an efficient regulator, for an efficient licensee, it needs to be paid a return which is commensurate to risk. And the current return, in terms of that, was worked out the number at about 7.1%. However, that's not what is being paid. But that's where now, when we are balancing the interests of the consumer versus the interest of the utility, that's the number that the regulator played with. So that's the number which has been played with. Eskom had itself applied for a negative return. The regulator has given a positive return. Is it a great return? The answer to that, obviously not. But if you are balancing the interest of consumers with the interest of the utility, that was where the balancing act was actually made. So that was where the number comes in. But is it cost reflective? Yes, in terms of Eskom's cost, the attempt was made to reflect all of the costs, the real costs, including some of the subjective costs that have been put forward. What was the outcome of the meeting with Minister Montage? You know, funny enough, because I somehow predicted that this question would come. We met other ministers, but the question was going to be Minister Montage. And Mr. Montage unfortunately listened, and he said, "Thank you for the briefing. You are here to brief me." And in fact, even when the colleagues, the DGs and some of the people in the room were asking questions, he said, "You are not the regulators. There's only one regulator, NERSA. NERSA is here to brief us, to indicate what they expect, what they might be recommending to the energy regulator, and thank you, goodbye." And emphasize the independence of the regulator. That says the decision that's going to be made will be made by the energy regulator. And that's about it. Whilst other ministers may have asked more detailed questions, may have interrogated, may have even asked in terms of, we may even have indicated, say with Minister at Kokta, to indicate that if the arrear debt, for instance, is largely because of municipalities, what is it that, Minister, you can assist us and assist Eskom with, such that those arrear debts can be, because at least they are contributing towards those costs. They did engage with us, but Minister Montage did not, unfortunately. And the question asked, I think I dealt with the last question. When will NERSA see and react to load reduction and quality of supply? Our NERSA, we are governed by the prescript. So to the extent to which the Electricity Regulation Act specifies NERSA's roles, responsibilities, and it specifies its functions and what it must do, what it may do, and what it may consider, the powers that NERSA has are drawn directly from the Electricity Regulation Act. Unfortunately, as we sit today, and I'm hoping that we as South Africa will participate in this amendment process, where in other domains, if somebody does not meet the obligation to supply, they are penalized. But that is captured in the law. Our law does not work like that. Yes, we've got a grid code, and as long as somebody, and the primary issue, for instance, about the grid code is about ensuring the stability of the grid code, that we actually don't get blackouts. So to the extent to which you need to actually protect the grid by reducing load, that becomes the primary objective, especially of national control. But going forward, if there's an obligation that needs to be placed on the utility to make sure that it supplies, that is something that is going to be an object of the amendment of the law going forward. I'm hoping, Program Director, I've responded to all of the questions, but if colleagues want to add, please feel free.
Thanks, Mr. Gumede. I think you have responded to all the questions. I'm not sure if ever are there any additions. I see Mr. Mkhize would like to just make some input.
Thanks, Program Director. And thanks, Mr. Komeda, for the responses. Just to touch on the issue of taking responsibility for failures of our system that was raised by we are South Africans, Mr. Martin. In our decision, there's a paragraph that, or a section that does deal with the issues of governance failures, malfeasance, fraud and corruption, which matters are being investigated, and we keeping tabs in terms of that, so that the outcome can flow through to NERSA in terms of the rands and cents that then relate to that. Moreover, the fact that we are also anticipating and expecting those outputs, it puts some impetus on those structures, the law enforcement agencies that are working on these matters, to then speed up in terms of getting to an outcome. I would also like to talk to the issue of the asset base, which Mr. Komeda very well articulated, in the sense that when one looks at Section 15 of the Electricity Regulation Act number 4 of 2006, as amended, is that there is also a need to provide for or prescribe incentives for continued improvement of the technical and economic efficiency with which services are to be provided, which is 15.1b, which will then also going forward further explore to provide expression, particularly when it comes to the issue of the energy availability factors and the plant, as well as the whole system performance. Thank you.
Thank you, Mr. Mkize. I think the chairperson also want to make some input.
Thank you very much, Program Director. I just want to emphasize one point that Mr. Komeda has made in response to the question as to what did the Minister say. I'd like to preface it by indicating that as an independent regulator, all our decisions are dependent on the members of the regulator. However, it is customary through the life of the energy regulator that as they approach a particular decision, and as Mr. Komeda has clearly pointed out, one is to ensure that the information is correct. Secondly, there are areas that are in the application that are not within the purview of the regulator, and one of them could be, the carbon tax, could be environmental levy. Needless to say, those kind of elements within the revenue application cannot be touched by the regulator because they are outside of our review. So to an extent that we would seek and advise the ministers at the right time, as you can see, is close to the decision. There's no way that we have spent more than 3 months looking at a decision and then we expect any change in the last minute. So it's really the economic ministers and the governor of the Reserve Bank that we advise and we brief and we seek some additional support, if any, where they've got control over issues that they have. I think that, and therefore, going back to the answer that Mr. Komeda pointed out, these are not decision-making exercises. These are meetings to brief the policymaker, and therefore our decisions will remain independent. Thank you.
Thanks, Chair. I think we have gone beyond our allocated time. But we can take another set of questions. I think I earlier saw on Paul's hand was up. I'm not sure if ever, Paul, you still want to ask the question. I see Terrence's hand is up. Yeah, I think those are the two hands that I saw. Yeah, so Paul, you can go first, and then it will be Terrence, and then, of course, Antoinette. Yeah, in that order. Paul, we can't hear you. No, it has been. Okay, we'll move to Terence whilst Paul is sorting out the technical challenges. Over to you.
Thanks, Charles. Just a couple more. Has the extension of phase 1 of the carbon tax been reflected in today's determination? The decision was made, was announced in the budget yesterday, which I imagine has some implications for how much should be levied against the carbon tax. And secondly, what amount did you eventually approve for diesel, given that there was quite a lot of contention around whether that was a prudent expenditure to offset load shedding? Thank you.
Thanks, Terence. Antoinette, you can go ahead.
Can you tell us when you expect to publish the reasons for the decision, please? And then I'm sorry, I must apologize if I picked on Minister Montage. I thought it was the only minister you met. Maybe you can just, for the record, tell us which other ministers you also met.
Thanks, Antoinette. I think the panel can respond.
Mr. Guma, let me just take this one. We brief economic ministers and such other ministers that are immediately related to the matter. If you look at what Mr. Gumeta has given in terms of starting with the tariff process through to municipalities. So just to give you a broad outline, that would be a Minister of Finance, the Governor of the Reserve Bank, our own minister, the DTIC, Public Enterprises, and of course, COPTA. Unfortunately, in this particular case, we met 3 ministers because the timing, as you can see, it would be difficult, for instance, to meet with the Minister of Finance, given the budget vote yesterday. So it is that particular process that may have some contribution to make in terms of those areas where we don't have jurisdiction. I'm not sure whether you'd like to add, colleagues.
Let's try and see whether this one works this time. Is it audible? Okay, thanks. Does look like there are gremlins, Gerard, that you are putting on my mic. But anyway, the date of the publication of the RFT, we basically have 60 days after decision, because we would need to consult the applicant after the decision has been made, and allow the applicant to apply for any matter that they may want to be considered to be confidential. And also just to remove the gremlins, because there are always gremlins. These are numbers that are being crunched. So sometimes, for instance, there would be a slight correction in the media statement of the in terms of the RAB. Colleagues somehow swapped the 2 numbers. It actually doesn't change the calculation, but there were clearly some number challenges. There were other challenges as people were trying to copy one number to another. So they actually swapped the numbers around. But that happens. So we do need to allow time for that to make sure that the actual RFT has been properly it's been edited and corrected for any gremlins, but also primarily to allow the applicant an opportunity to indicate which aspects it considers to be confidential. But Terence, carbon tax. During the public hearings, there were questions raised and concerns and maybe even requests made that perhaps, from some quarters that would say, can some of these decisions be deferred? Unfortunately, Minister of Finance indicated quite clearly what can and cannot be done in the context of our commitment to the Paris Accord and other things. So that is happening. However, there are also deferment periods in the process. But although those and Eskom would be very well versed with when they actually need to collect and when they need to pay over, or when they can still be whether they actually do have the time perhaps to actually defer putting forward that amount, or whether even if they do collect the amount which has been indicated in the application, which is a figure of 2.7 billion for the 22-23 period, that if they don't, even if they have to collect it but don't have to pay it over, but they have to pay it over later, they would then have to actually ring fence it, put it into a particular account, because even if it's deferred, it will have to be paid over later. So, but that would actually have to be left to Eskom, but clearly monitored in terms of that 2.7 billion, which would be a carbon tax, if it's deferred by National Treasury in terms of payment, that is actually ring fenced and put aside and not used to fund other things. Not that I'm insinuating Eskom does that, but I'm just, but anyway. The diesel amount, Terence, this has been a key issue. And if you allow me a little bit of leeway here, Terence, is that Eskom had previously applied for a 1% load factor on the use of OCGTs. Then, because it became clear that some of the projects, especially the risk mitigation projects, were not going to come on stream next year or in 2022, then it became clear that you would then have to have this, you then have to still have this dispatchable power that may be generated. So it raised two issues. It could be generated using coal, if it's appropriate to use coal plants. But for peak load, for instance, clearly, if some of the plants that were meant to deal with peak loads do not come on stream, then it forces then Eskom to actually then either it then load sheds during that period, or it then uses the more expensive OCGTs to actually meet the load. So there has been then subsequently then applied for a much higher number of a load factor, I think 6.5%. But the colleagues, when they were engaging with Eskom and doing their evaluation, we had a landing of a load factor of around 3.5% or so. But the RFD will actually give proper details on that. But that is is actually aimed at saying, and we must correct this. Not the use of OCGT is not just because of low EAF of Eskom plants. It sometimes would be inappropriate to deploy a coal-fired plant that you need to ramp up or start up or something so you can meet a load that's going to come in at 5 and disappear at 9. It would be inappropriate to do that. So the use of OCGT must, and this is what we've committed to, is to have a better study as well as NERSA to better understand this, to understand that where is it that is appropriate, where OCGT or diesel is used appropriately, and when is it not used appropriately. So it's not just linked to low EAF, but it's linked to the fact that you may have some types of loads that demand the use of OCGT. I thank you. I think we've addressed all of the questions. Thank you.
Thanks, Mr. Gumede, and the chairperson for the responses. I don't see any hands. Which will mean that it brings us to the end of this media briefing. And I just want to thank members of the media that managed to, attend this briefing. And those that joined us via Teams, we really appreciate, your presence, and also our key stakeholders that managed to attend, and of course the panel, for the presentations and the responses, to the questions. Thank you. This brings us to the end of the briefing session. Thank you.
Thank you, Charlie.
you.